Welcome to the world of child custody. Let's start with our Child Custody 101 course. My goal is to share as much information as possible and as quickly as possible. This video is probably going to last a little more than 5 minutes, so bear with me. But it'll be worth your time to learn early on in the process, because learning by trial and error is not an option during a custody fight. Let's start with some terms. Child custody, visitation, parenting time, legal custody, physical custody. These are all terms that you're going to have to know when the judge is discussing all of these different types of custody or parenting time issues. Legal custody, you shouldn't be hoping and guessing what it means. Legal custody is the process of decision-making about your children. The parent who has legal custody is allowed to make the decisions about the child's schooling and medical care. Joint legal custody means that the two parents share this decision-making responsibility. Sole legal custody means that only one parent is going to make those decisions. Joint legal custody is quite commonly ordered, but not necessarily always. When a judge awards physical custody, the judge decides with which parent the child is actually going to live. Again, there's the option of sole or primary physical custody when the child mostly lives with one parent. There's also the option of joint or shared physical custody when the children lives part-time with each parent. Here's my first tip that makes it worthwhile watching this video. Don't get hung up on the terms of sole or primary or joint or shared. What actually matters is the parenting time order. So let's move on to the next term, parenting time. When a judge orders parenting time, used to be called visitation, the judge outlines where the child will actually live on a daily basis. So, getting back to the tip that I just gave you, don't get hung up on the term of primary or joint, because a judge may award you joint or shared physical custody, and you might think, wow, it's time to celebrate. But if the custody order only gives you every other weekend parenting time, you may have gotten tricked into a bad order. The joint physical custody order and the parenting time order, in that case, don't match at all. Good judges and good attorneys will not trick parents like that, but it happens. So pay close attention to how much time you're actually getting to spend with your children. Don't get tricked by the terminology. Moving on to child support. You should anticipate that the judge will require a child support order to be entered. Not all child support orders require one of the parents to pay child support. Child support is calculated based on a strict formula. If parents, for example, earn the same amount and they equally share parenting time, they may end up with a zero child support order. My second tip is to calculate the amount of support that you'll end up paying over a 3 to 5 year period, for example. You may think that $100 extra per month isn't all that much. However, if you overpay or underpay $100 every month, that's $6,000 over a 5-year period. On the other hand, if you're arguing over a $50 difference per month, but you spend tens of thousands of dollars on an evidentiary hearing or trial, that's not worth it either. Because child support can be recalculated every 3 years. In fact, child support can also change if there's a substantial change in income for either of the parents. Next, I'd like to talk a little bit about the process of a custody order. Judges and parties attending a hearing have to follow Michigan court rules. If you don't follow the court rules, the judge could punish you or deny your request or order you to pay a fine. If the court rules aren't enough requirements to follow, each court has its own procedures and rules. And if that isn't enough, some judges have their own requests and rules and procedures. So, this is a long-winded way of saying no two courts or judges are exactly the same. I can't give you a one-size-fits-all outline how the process works in every court, but there are some basics that are always the same. The most important basic lesson is that there are two ways of getting a child custody order in place. You either reach an agreement with your ex, or the judge decides child custody for you. And that leads me to the third and most important tip in this video. If there's a chance to settle your case, give that option some serious consideration. Don't fight simply because you're angry at your ex, or your ex did some mean things to you, or did some bad things, and you want to make sure that it goes on the record. Going to trial doesn't take away the hurt of a bad relationship. It doesn't fix the wrongs that occurred. Instead, going to trial gives you the potentially an unpredictable result. Let me explain when an unpredictable result happens from a judge's ruling. For example, when you negotiate a parenting time order, you may reach an agreement for a Friday evening pickup and drop off. But then you realize traffic is bad, you'll never be able to make it to your ex's house by 5 p.m., so you negotiate for a 6 o'clock transfer. When you get a judge's decision, and they're not aware of all of those facts, the judge might not take into account your traffic difficulties, and they'll simply pick a time, and you'll have to live with it. What's worse, you've been fighting for a while, and logically, you probably see your side of the story. But you could be in for a rather big surprise when the judge doesn't agree with your perspective. There are several ways to avoid those kind of surprises. An experienced family law attorney should be able to give you an estimate of what to expect when you go to court. Will your attorney always be 100% accurate? Absolutely not. Your attorney only can hear your viewpoint. Your ex and their attorney could appear at the hearing with a big surprise. It happens. Sometimes judges have a bad day. It shouldn't make a difference, but it happens. An experienced family law attorney will assist you with finding an experienced mediator. A mediator can help you settle your case. The key here is to finding an experienced mediator. An experienced mediator will anticipate how a judge will likely rule in your case. That's important. I have some more information about mediation in another video. Of course, you shouldn't just simply settle your case at all costs. You need to know when to fight and when to buckle, and that requires expertise and experience. If you don't reach an agreement about custody, the judge will issue typically a temporary order soon after your case is filed. To get a temporary order in place, one of the parents has to file a motion requesting such an order. The temporary order will typically stay in place until the judge changes it or until the judge makes a final decision. Sometimes the judge will request the friend of the court to help with a temporary order or to investigate your situation before a final order is entered. Watch my video about what to expect at friend of the court to learn more about that. You'll need to consider discovery. Discovery is an investigative process. Some discovery is almost always necessary. You'll need to review your ex's income, their health insurance cost, the daycare cost, all in order to calculate child support. If there's a chance that you will not settle your case, you'll need to perform significant discovery. I have another video where I discuss discovery in depth. Finally, the process of getting the first child custody order in place may take several months. This order can be changed when circumstances change or when there's proper cause. So, there you have it. The basics you need to know about child custody. Talk to you soon about some of the other important next steps.